Hello, Kendall Coffey. How are you, sir?
Hey, Steve. Happy Friday. I'm doing great. Great to hear your voice and hear our music together.
Yeah. We got a song. You know, I mean, it's your
We
song,
do.
but it's our song, is it
It's
not?
our song.
It really is. All right. Well, we have some interesting cases to discuss. And let's start with something the Supreme Court did decide. And they decided that police officers in Pennsylvania no longer need a warrant to search citizens' vehicles. Now, talk about that. And does this only apply to Pennsylvania? And can this spread?
This is the decision in Pennsylvania, in the Pennsylvania Supreme Court.
Oh, I'm sorry.
And,
Yeah. It wasn't over there. Right. It was a state court. Yeah, state Supreme
and
Court.
so if you're in Pennsylvania, it's a big deal. But outside of Pennsylvania, it depends on the state laws and how they're interpreting their own state constitution. For U.S. constitutional principles, for purposes of federal agents, they don't need a warrant to do a search of your car. There has to be probable cause, but they don't need a warrant. And the theory of that, Steve, is if it's an automobile, to go contact a magistrate, run down, do the paperwork, come back with a search warrant.
That's impossible. Yeah.
So it's a very practical and realistic scenario that the U.S. Supreme Court has permitted with respect to automobile stops. Now, the state Supreme Court, each one, probably just about everyone, I think, has their own state constitution, and they can, of course, apply their state constitution for state officers and provide more rights than the U.S. Constitution provides. That's the way it stood in Pennsylvania until this decision. Now, in effect, the Pennsylvania State Supreme Court has confirmed the kind of searches officers in Pennsylvania can make to the law of the United States and to what federal officers and agents can do.
Yeah, and it's interesting because under the prior law, an officer, for instance, if they smelled marijuana, or they could only search the car with the driver's consent, or if illegal substances were in plain view. I guess so. They're mainstream now because I can't conceive of how a cop, with a suspicion, reasonable suspicion to search someone's car would be denied permission by the driver and then have to go through that whole thing. As you said, it's impractical, and I can't even imagine how they would have ever done it.
Yeah, I mean, there's some outcry from defense lawyers in Pennsylvania, but this decision really seems like something that one should have expected because, again, it conforms it to searches that are permitted under the U.S. Constitution. As you say, you can always search a car with consent if contraband is in the plain view, and of course, with a warrant or if you see some kind of emergency. But U.S. Constitution, now the Pennsylvania Constitution, says if an officer has probable cause, more likely than not that a crime has been committed and that there's evidence of the crime inside the car, the officer can proceed further now in Pennsylvania, like most places.
All right, now, with my head on a little straighter, the Supreme Court of the United States ruled 6-2 this week that the Environmental Protection Agency, the EPA, does have the authority to regulate power plant emissions that cross over state lines. This is a so-called good neighbor rule. And coal-fired power plants, like in West Virginia, will be liable for damage that it might cause by mercury or sulfur dioxide that end up in, let's say, Pennsylvania, since we were talking about them before. So what this is going to do, according to many industry experts and people in the business, it's going to make it difficult for these coal-fired plants to operate.
Yeah, and standing alone, this decision didn't have as big a practical impact as you might expect because the EPA had already done other rules after they lost the case at the appeals court level in 2012 to more or less create the same restrictions with respect to coal plant emissions. But apparently it's going to have or could have a significant impact on states like Texas. And I think a broader concern industry has is this going to give EPA the sense that, hey, we just got a lot more power. Let's look around at other rules and regulations that we can make with respect to coal as an energy source. And we know that about 20% of America's energy originates in some form or another from coal.
Yeah.
We know that, whether you're liberal, conservative, butcher, baker, candlestick maker, all very committed nationally to trying to get as much energy independence as possible. So
Right.
there is a concern that the goal of energy independence is colliding with aggressive limitations on, in effect, creating our own energy.
Yeah, no, absolutely. And as I told our audience when this decision came down, if you go back to listen to some of the things that Barack Obama had said when he was running the first time, he talked about how it would, electricity rates would skyrocket by definition under his energy policies, and that it would be very hard to open any new coal plants in this country. So we'll have to keep an eye on the effects of that, certainly. And it's not the first time the Supreme Court, Kendall, has weighed in on the side of the EPA when regulating carbon dioxide as well. They or classifying it as something that might cause global warming. They also weighed in on the side of the EPA with that a couple of years ago. Let's talk about this ex-cheerleaders lawsuit against a website, former Cincinnati Bengals cheerleader, and it brings up the question of what are the rules for the internet, and this case could have very broad implications, I would believe.
Well, this case could be a powerhouse, depending on where it goes from here, because what it establishes is that somebody who's operating internet media, who's got a blog or who's got some other internet publication that allows comments to be posted, has pretty much thought that anything goes. That under the Communications Decency Act there was broad immunity, so let people post all kinds of, in some instances, outrageous and malicious things. In this case, as we know, this former cheerleader was pretty badly slimed, to use the term from Ghostbusters. Nonetheless, the position of the internet media was that under the law, and the Dirty.com's position was there's federally imposed immunity. What the court held in this case is, hey, don't be so confident of that. If the internet media publisher is, in some sense, involved in encouraging the postings, approving the postings, more than simply being a neutral bulletin board, then there can be liability. And that could have an explosive impact on all the internet publications out there, of which there are gazillions, that thinks that pretty much it's anything goes as long as somebody else is posting the dirt.
Right.
None of that mud splatters on the publisher.
Does this case really go against, counter to all other similar cases that have come before it?
Well, it's distinctive, and you'd have to say that the general indications of courts had been different than this outcome, but the facts here are very strong in the sense that the defamatory allegation was pretty outrageous, and the judge thought there were some distinctive facts. They're saying basically the internet publisher was, in a way, complicit and encouraged and incited these kind of attacks. So we've got to watch this one closely, because this could really have a transformational effect on the way comments are being posted and the way internet publishers are allowing or disallowing them.
Last year, we got 2 minutes left. Last year, a teacher in Montana was sentenced for after being convicted of raping a young girl to a month in prison. And turns out that this week the Montana Supreme Court overturned the 1 month prison sentence. And it was a 14-year-old student, the whole thing. I have no problem with this guy rotting in prison for a much, much longer time. But tell me about the legality of, going through the legal process, being found guilty or not guilty for that matter. If you're found not guilty, you can't be retried, double jeopardy unless it's federal charges of civil rights violations. But how can a sentence from a judge be appealed and then redone? Tell me how that works exactly.
Well, you make a great point.
We only have a minute, I'm sorry to say, but go ahead.
I'll talk fast. Double jeopardy goes to whether you can be tried again.
Right.
And if you're acquitted, that's it.
Right.
Game over. But what can be done is, after a conviction or a plea, if the sentence is too lenient or too harsh, the appeals court can look at it. This was an outrageous sentence, as we all know. And the court obviously corrected it, not only sending it back, but saying a different judge has got to impose this sentence because the last judge was just too far.
Interesting that you could appeal it too lenient or too harsh. See, I could see appealing it for too harsh, being consistent with, if you're found not guilty, you can't be tried again. But doing it either way kind of flies in the face of the double jeopardy. Again, I hope this guy gets many, many, many more years, but I just had a problem with the concept of it. Kendall, thank you, sir. Enjoy your weekend.
Hey, have a great weekend, Stephen.
Take care. Kendall Coffey, ladies and gentlemen. And Spinning the Law with the great Kendall Coffey, author of a book by the same name. Check it out if you've never read it. We're coming back with Gimme 5. Have you read that book? Steve Malzberg Show.